Cleveland. So Wes, please introduce yourself and give us your insight.
Yeah, I'm Wes Cleveland, been in practice for over 20 years, represented physicians the whole time during that. So now I'm at the AMA. So what I'll do is I'm going to give you sort of the highlights from the from the proposed rule, and I'll just briefly give you AMA policy so you know where the AMA stands in terms, like I said, of its ethical policy. Okay, so we're talking about physician non-competes. As it's proposed, the ban would generally the rule would generally ban physician non-competes, and I'll tell you why I'm using the term generally. Okay, so when we talk about non-competes, we're talking about the post-employment restrictions on where a physician can practice and for how long. So it doesn't prohibit non-solicitation provisions about trade secrets, reasonable liquidated damages, things like that. It would preempt all contrary state law, right? So if the state doesn't ban it, but has a reasonableness analysis, that analysis would be preempted. All non-competes would have to be rescinded within 180 days after the effective date, whenever that might be, if the rule is adopted as proposed. Comments are due by March 20th, unless there is an extension, and there are a number of parties that have asked for an extension of 60 days. Okay, so that's basically it in terms of the ban. Now, this is kind of what I want y'all to hear from me, so this has to do with expectations. Okay, this rule was adopted, or proposed, I should say, it was proposed under the Federal Trade Commission Act. All right, and the FTC, under the terms of the act itself, doesn't have authority to regulate certain industries, banking, common carriers, things like that, and entities that are not organized to carry on business for their own profit or those of its members. Okay, so what does that mean? All right. It doesn't mean 501c6s, okay, because the Supreme Court has interpreted that as a nonprofit that does carry on business for the profit of its members. But the open question is whether that includes 501c3 hospitals. And there will probably be some 501c3 hospitals that satisfy that definition and thus cannot be reached by this rule. And so the thing I would want, that's going to be a contentious issue in the healthcare sector, especially between hospitals and stuff. So, but if the rule were passed, a physician who wouldn't be aware of this, if it were adopted as is, and that's a big question, right? But if it were, all right, and if it got through the legal challenges and stuff, a physician that was contracted with a 501c3 hospital and had non-compete in there, I'd say, hey, look, FTC's adopted this rule, 501c3 health system, you've got to take this out. And the response very well may be, that doesn't apply to us, and then so many hospitals might take that position and just wait to see if the FTC challenged whether or not they in fact met that exemption. So that's an issue that's out there. All right. The jurisdiction of the FTC is not, doesn't apply across the board. So that's why I say the term generally, right? And so the AMA policy, as you know, we have physicians on both sides of the issue. So the policy recognizes that covenants not to compete can restrict competition, disrupt continuity of care, and may limit access to care. Those are all true. And so according to that policy, the AMA opposes the use of unreasonable restrictive covenants in terms of time and geographic scope. So that's it for me.
Okay. Wes, thank you very much. I think maybe we'll go to give them more local level, Illinois State Medical Society. David Porter and I think we'll end up the conversations with Dave Becker, but I'd like maybe Dave Porter talk next about the Illinois State Medical Society, their position on this, and maybe ways we can help influence the DuPage County Medical Society and Illinois State Medical Society as they go forward. So David?
Great. Can you all hear me?
Hear you great.
So Dr. Yap, thank you very much. I'm David Porter. For those of you who don't know me, I'm the Senior Vice President for Health Policy here at the Illinois State Medical Society. This has been an issue of some debate and disagreement within ISMS for a number of years, obviously, particularly since more and more physicians became employed over the last 25 years. Illinois actually has a lower percentage of employed physicians than the national average, but it's still a very touchy issue. Our policy was most recently updated in 2018 after a very long and robust debate between the employed physicians, mostly hospital employed, and those physicians who actually employ other physicians and who worry that their MD employees might leave the practice and start a competing practice in the same neighborhood or the community. And so we crafted sort of a middle of the road policy, probably similar to the AMA's. The ISMS policy reads that ISMS supports abolishing restrictive covenants or post-employment non-compete clauses from any contract of a hospital or hospital affiliate as defined by the Illinois Hospital Licensing Act. I believe the author of that resolution is Dr. Lycan, who's here on the call today. It's also interesting to note that in December of 2021, we changed our law here in Illinois about non-competes, not really specific to things that would touch medicine, but we updated here in Illinois, not the State Medical Society, but the General Assembly updated our Freedom to Work Act here in Illinois to prohibit employers from entering into non-compete covenants with employees making less than $75,000 annually. And that law also periodically updates that $75,000 number, ratchets that up over the course of 15 years. The law was also changed to prohibit employers from entering into covenants not to solicit for any employee making less than $45,000 annually. So again, that number was ratcheted up periodically. So we have shown a proclivity here in Illinois to actually pass a law to try to prohibit some of these things. I have been asked, is this something that the ISMS would comment on the federal level? And I think I would say that we don't really have much to offer other than the policy that I just read to you. And we'll, of course, share that with the AMA. They've asked the state medical societies to share their opinions on this. I think it's important to note that our policy is really a reflection of our membership and more importantly, members who are willing to engage on these types of issues. So I guess I would close by just making a pitch for ISMS membership. And if you want to have an impact on the policies that we pass, then you have to be a member and you have to stick your toe in the water and you have to engage. And I know that there are people who want to change ISMS policy, and my response would be, great. I'm happy to work with any physician to introduce a resolution that would, again, open this debate and perhaps change our policy. So with that, thank you for having me here. And I think it's a very interesting subject, and I'm sure our membership is going to remain somewhat torn on this issue. So thank you, Dr. Yap.
David, thank you very much. I will also say the last time the ISMS, I think I was at that meeting, it was an interesting debate. I saw one side of very young, vigorous doctors and another side of doctors that are now starting to look more and more like me. So today, but it was interesting. There's a little bit of dichotomy, but I also say it's interesting because the world of employed physicians has changed a lot since 2018.
I agree.
Yeah, so there's a lot more. So physicians employing physicians still happens, but it's becoming a very smaller and smaller universe. Yeah. And the fact that venture capital companies and for-profit companies and hospitals are employing more and more. They're non-physician. I think the world's changed a lot, and I maybe Dave and I will talk about this a little bit later in our discussion. But I am one of those who wants to. I need help from people who want to join DuPage County Medical Society and Illinois State Medical Society. Want to help to change the ISME's position, and I think if we do that, I don't know if many of you know this, but ISME is probably one of the most influential state members in the AMA, and they've had many presidents of the AMA come from Illinois. They've had many of the key leadership roles in the AMA. So the AMA looks to Illinois in a big way. So it's a really, how you ended talking about us getting involved, I think is important. So our last speaker, and then we'll get to some quick questions, is David Becker. I met David Becker through a mutual friend. He's working with other groups of physicians who are trying to stay independent, physicians that value the expertise of someone like David, who has counseled and given advice to many physicians and also employers about this. So I met David a few weeks ago in the encouragement of some friends and asked him to join. And David, thank you so much for doing this. And please, we look forward to hearing your insight and wisdom about this topic as well.
Sure. And, the way it was put to me was, well, first of all, I'm Dave Becker. I'm a partner with a firm called Dickinson Wright. I'm right downtown in Chicago. And I do counsel on both sides of this. I help people enforce non-competes. I help people avoid non-competes. And I also work with people as they're going into employment and figuring out how to negotiate those agreements. Usually when I'm fighting outside the medical context, there's a lot of good bases to argue about whether there's a protectable interest. Courts in Illinois are pretty sold that medical practices have a protectable interest. So the issues generally in a medical enforcement are going to be about the reasonableness of the restriction. So you're usually fighting about how big the radius is, and that changes when you're out in DuPage. There are cases once you get further out from the city, 20 miles might work. Downtown, a mile, 5 miles, that can really impact things. And if you're, so those are generally the arguments you're going to get to in court. Unfortunately, David took a little bit of what I wanted to talk about, which was this act that was passed recently and things that people should be aware of. There's a couple of additional points. If you guys have non-competes in any agreements you're working with, and those, the act that Illinois passed also requires that you give somebody 14 days to review it before executing it. It also means you can't enforce an agreement against somebody who lost their job due to COVID-19. So if there were job cuts under that. But the other impact of that law is that I think you're going to see a lot more people in Illinois focusing generally on non-solicit agreements and confidentiality agreements or non-disclosure clauses within agreements. Those are generally things that courts see very good reason to let people protect. I mean, as much as somebody might want independence and ability to work, there is a world in which courts find it fine for a company to say, if we've been supporting you with this group of patients, you can't go across the street and work for the same patients for a while. And that's just kind of how the law is. I would suggest that if people are like Rocky and they want to avoid these things, negotiate on your way into your job. Tell them, if you want me, I'm not going to sign that part, and see what happens. Large hospitals, you're going to have a problem with. They have a policy. They have to run it across the board, or it'll be a mess. Smaller practices, they may want you to join. So, think about where you stand in your profession and negotiate hard if you want to. Other than that, the conversations I've been having with Rocky and Wes before we got on here was about sort of postulating as to how much impact this is actually going to have, if it's going to go through, and what will happen. Happy to be a resource on that and further the conversation.
Okay, David, thank you very much. Those are great opening comments. So we're starting to get some questions up on the side, and please, anyone who's on who wants to ask questions, please do. I have a couple of perspectives that I've shared with our speakers and just give their comments. I will, as a disclosure, I am an old guy. I've employed physicians and many healthcare professionals. I'm also a founder of one of the larger specialty groups in Illinois. And we made a decision from the very beginning to avoid non-competes. And in that process, we were able to grow and expand and do some great things. But it also had some downsides. So some of those people could leave easily, and some did, went to venture capital. Venture capital is a very attractive for a lot of physicians, especially older physicians. It is not, in my opinion, as attractive for younger physicians, but it is something that I find very interesting. So to me, the positive, especially for younger physicians just entering the practice, who are, in my opinion, are largely naive about the business of medicine, about they are world-class training, they're experts in their field, their specialty, but they lack sophistication and knowledge of really the business of medicine. And non-competes have been abused on many of those physicians, especially I think since COVID, there's been a lot of concerns I have. So I guess I'll open up the panel, and maybe I'll let David Becker speak first. But I think there's obvious pros for avoiding non-competes as a physician who's about to become employed, and the majority of physicians are looking to be employed. They're not looking to hang their own shingle. I think, but are there downsides to getting rid of the non-competes? And should I say, is there some benefit for a non-compete for an employee? I don't see it, but I'd love to have your perspective, and then maybe Wes and David give their thoughts too.
From an employer perspective?
Employee perspective. Is there any benefit at all?
For an employee?
Yes.
Oh, no.
There's not.
A non-compete is a non-compete purely protects the employer. This is a question of, unless you're a co-owner, a lot of you guys run partnerships, and in those instances, you don't want, you guys have decided to partner up. And first of all, you're going to have some issues just in your partnership with regard to fiduciary duties. When you're leaving, what you do and how you do it is dictated by fiduciary duty law, and you can get in a mess if you start talking to patients before you leave. So there is a legitimate interest for a business to maintain that business and be able to continue to provide service to people. And some of the practices we're talking about are small, some are large. The larger they get, and in certain contexts, I get that there's really no benefit to the employee, other than, let me think creatively for a moment, the prosperity of the business. So you get paid because the business does well, and that helps to maintain that value.
Is there any bargaining power for a physician to say, increase their leverage if they express a willingness to sign a non-compete? That's a nice offer, but I'm happy to sign a non-compete if you offer me more money.
It's an interesting play.
Yeah.
It depends on the employer. If the employer's not asking for non-competes to begin with, I don't know how much value they put in it.
So David, what about the former DuPage Medical Group, Dooley, or Springfield Clinic? You mentioned fiduciary responsibility. Do you think that the partners in those groups do not have non-competes?
I don't know what happened with those two things, so I don't know what the situation.
I'm just using them as examples. I just don't know how this plays.
I can tell you, I know a little bit about Dooley, and if someone Dooley on this call, please raise your hand and we can come to you. My understanding that Dooley has non-competes for all their partners, and it's relatively stiff. I also compete against an organization called GI Associates, which is a 800-member GI physicians across the country, and they have non-competes not only for their local group, but within a radius of several miles from any of their organizations. Whether it's so if I'm in Chicago and I want to move to Texas, I could be banned from moving to Texas by their non-compete because they enforce that. So there's some,
I think that would be very difficult to enforce.
you'd be willing to take that.
Very difficult to enforce.
Okay, I will let my
You
friend-
are, if you are a doctor working in the Chicago area and you move to Texas and they try to enforce a nationwide restriction,
Well, it's 23 states.
I think it would be very difficult to enforce that in most states.
So let me ask you a question, another scenario, David. David Becker, maybe you can answer this. What if it's a person working in Bourbonnais for GI or a venture-backed company, and then they want to go up to Condell or go up to North Shore, and both places have, and I'm just using GI. Forget about GI. Just a multi-specialty group that has offices both in Bourbonnais and up in Lincoln Park, or have up in North Shore. Can they enforce? Would that be enforceable?
You're going from Bourbonnais to North Shore.
Yeah.
So look, my argument would be that it's not enforceable. If I'm defending the person, my argument would be that that is a unreasonable geographic restriction. Bourbonnais to that's what, 50 miles?
Okay, 50 miles, right.
A 50-mile restriction is,
But they
this
would,
is when you do get to the legitimacy of the business interest of the business.
a hypothetical story is they would have a partner in Bourbonnais, and they'd also have a partner in North Shore within the radius they agreed to. It's an interesting question. We're getting too much in the weeds and too many fine details, but that goes back to how much I think these non-competes are so stifling. Because if I'm a young person and I have the threat of a non-compete over me, it is a tremendous inhibition for me doing anything.
But can I add one thing
Sure.
that I didn't touch on? But okay, so for every state that has a statute, even a non-compete statute, even a statute that prohibits non-competes, okay, they all have exceptions for what we're talking about here, like partners in a business, okay, which is, and so I'm saying this because some of the groups, right, some of the physician groups and employed physicians, they may want to comment on this rule aside from just the employee issue, because the general ban on physician non-competes does have an exception, like all other states have, regarding the sale of a business, okay? However, a non-compete is only allowed in the context of a sale of a business if the seller owns at least 25% of the business. And that is a much, much higher threshold than what exists in the states currently now. And the FTC wants comments on that. Some have complained that that's just an arbitrary number. I don't know how they come up with that, but you're talking about shrinking down that exception to very few circumstances. I mean, clearly,
Well, and you could create a weird ownership structure just to avoid those circumstances.
you bet, you bet.
So let me just give another hypothetical. And just, well, first of all, we're getting some questions. I am I'm amazed so many of you actually appear to be my name. I didn't know I was cloned so many times, but there's a person.
I thought you were seeding the room with all of your relatives, Robert.
Yeah, I call them all. Everyone to just really go my way. But
Yeah.
one of the first questions is, what are the pros and cons of the rule gets passed regarding independent and employed physicians as well as big corporations? I'll go. Maybe Wes, you have a perspective on that, and then David, you can give your thoughts.
All right, so the question again, can you say that? I don't know if I'd be the best person. I mean,
Okay, so
Dave
I
might be the best for
what are the pros and cons of this passed regarding independent and employed physicians? And then they also want to know about big corporations. So I guess one of the things, I can't remember who I talked to one of you about this. Maybe it was Wes that they said that venture capital companies are more vulnerable than perhaps 501 or nonprofits. And
Yeah.
was it US we talked about that? I
Yeah,
thought it was
yeah,
you.
yeah, that would be true, right? Okay, because again, if we talk about, well, this is kind of going back to what I said, right? This is a statutory thing for the FTC's authority under, for the FTC's authority that concerns the scope of the rule, right? So any for-profit entity, all right, is going to be subject to the rule, okay? But the FTC there are certain, or if the organization isn't carried on for the profit of itself or for its members, okay, then it will fall outside the rule, okay? And so you have this question as to the extent of which, if you have a big corporation like 501c3 large hospital system, whether this ban, even if it went into effect as it is right now, whether that would apply to that 501c3 health system. And I would expect a number of those systems would say, no, it doesn't, and then would wait for the FTC to challenge them.
Would you expect some hospitals to maybe change their designation to become 501c3 so that they could be exempt from this prohibition on non-competes? My first reaction is this would affect what's going on in Illinois, particularly in the western suburbs of this massive expansion by these huge health systems. I think a lot of physicians would re-examine whether they wanted to be employed by Northwestern or by North Shore, or I think so. They would change how this expansion is taking place in the suburbs of Chicago. That would be my opinion, because you might have people that want to start their own thing that's smaller and be more nimble and not be part of, Northwestern gobbling up everything.
If I can react to that, I think it's more likely that a large entity like that would just readjust their agreements. Like I was saying, this isn't going to impact non-solicit agreements. It's not going to impact non-disclosure agreements. People are going to be very crafty on how they work on those separate kinds of restrictive covenants to cover what they want and be able to accomplish things. Plus, I don't want to discount the level to which there's actual reasonableness in enforcement with a lot of the very large medical systems. A lot of them are not going to spend the time and money to pay me to fight, some independent doctor who's running around. I mean, let's talk about the real victim here. The real victim here is me. I don't get to charge a lot of money suing people over non-compete. So I just get to I just get to help them plan better agreements on other things. Now I do other stuff in my legal practice and I'll be fine. But there's a few folks who are going to lose a cottage industry that has been just delightful for profits for lawyers. So, but again, that's more a joke. My main point,
David, we're really worried about you. I just want to say
a lot of the medical practices are actually kind of reasonable about this. They know they have an agreement that might last 2 years, might be 10 miles, but they'll negotiate to say, yeah, as long as you don't go to this office for a while, or, just come to an agreement, come to a resolution, and they'll work it through. I've negotiated those. It happens.
So, David, I think we have
it's the group taking.
Dr. Likens had his hand up for a long time. Maybe we can.
I'm sorry, Doctor, please go ahead. Can you unmute him, Kate?
Yes, I just unmuted. So I was part of the 2018. I sponsored that. I also sponsored the Employed Physicians Bill of Rights that passed 10 years ago that has this in there. Actually, it was my son and I that co-sponsored it. My son was head of the Young Physician section at the time, and that's where all the youth sort of came through. This started, actually, we wrote this because my son had applied as a hospitalist at Skokie Hospital to moonlight about twice a month at nights. And they had a non-compete in there as a hospitalist, as a moonlighting hospitalist. The point is, I agree with everything Dr. Yap said regarding abuse. This has been abused overall, to the point that it used to be for people doing longitudinal care, internists, other specialists within their practice. And now it's being used for emergency medicine and hospitalists and others that make no sense in this way. I disagree with the aspect that I think the real victims are the patients in this way, because that restricts the amount of people that can work in that area. Northwestern, North Shore, Advocate, they have monopolies, basically. If you're a young physician out of residency or fellowship, you can't negotiate with these guys. My son couldn't negotiate with North Shore. Actually, it wasn't North Shore that the contract was with, and that's the question I have for Mr. Becker and Wes, because that contract, interestingly, came from Cleveland, Ohio. Came from another group in Cleveland, Ohio, that was farmed out by North Shore, Skokie Hospital, to do the hospitalists, to have enough hospitalists on board, in a sense. So the contract came from Cleveland, from a medical group in Cleveland that said you couldn't work within 50 miles of any North Shore satellite, even as a moonlighting hospitalist, in this way. And that's one question I had. Dr. Yep, and by the way, it was Brad Epstein from DuPage that really help us through. So the question I have is, Dr. Yep brought out the fact of national restricted covenants, so to speak. The question is, if you have a contract or a group based in one state telling in one other state that they couldn't do it, is that just as illegal or problematic?
So there's a lot. First of all, when I was saying the real victim, I wasn't talking about not the existence of non-competes. I was talking about the removal of them.
Oh, okay.
If they go away, I don't get to get in lawsuits.
Gotcha.
I'm not countering your statement. But on the point you're making, I think there's a lot of very unique facts to what you're talking about. So the source of the contract's not going to matter. It's the enforcement of the contract and where the work is happening. The other piece I would say is the contract itself would not be, there are very few versions of a contract that would be void on their face or illegal, except for the ones that are now illegal under the law because they impact somebody under $85,000, under $75,000, or under $45,000. Those are void. As a hospitalist, I assume he was still making over $100,000.
Not as a moonlighting hospitalist, no way. In the sense,
No, but his non-compete that wouldn't let him. Was it the place he was going to do the moonlighting job asking him to sign the agreement?
Yes, that's the point.
While he was still working for another.
Yes, he was allowed at another place to moonlight at Skokie Hospital.
But then Skokie said
that
sign a non-compete.
Right, Skokie said to not sign a
Knowing
non.
he worked in another place.
Correct.
Did he sign it?
I told him not to.
Did he?
What?
Did he sign it?
No, he didn't. I told him not to.
Would they have accepted his signature knowing that he worked at the other place?
They would have.
So here's the issue.
Yeah.
All of this doesn't matter until somebody enforces the agreement. Okay. So a lot of you, I mean, this may be mind blowing, but a lot of people won't enforce a non-compete.
But it's a threat of enforcement that's important.
Threat of enforcement is chilling, and it is. And in my practice, I would generally recommend to anybody, negotiate your way out. I'm leaving. I don't want to make any problems, but I am going to practice here. I view it as you're unreasonable if it is. If somebody's trying to enforce a national non-compete, you go to a lawyer like me, we look at the agreement, we figure out what it is, and determine the best way to deal with it. It is very difficult for a court to enforce an agreement that then says you, doctor, whatever, will not be able to practice at all. You may not be able to touch your patients for a while, but it is very often that a court is going to find a way to say, okay, put them in this silo, have them go to that office, something to make it so that you can work, because you're not captive to a company.
Right. Now, our only point was that it's been, as Dr. Yap said, abused to the fact that these non-competes are used universally, where radiologists as such, pathologists as such, and it makes no sense for that.
There's answers to this outside of what the FTC is doing. The state of Massachusetts has a non-compete law that forces you to give people garden leave. Essentially, you can enforce your non-compete, but you have to pay them to sit.
Oh,
And can I add,
Wes,
can I add a couple things to that?
yes, please jump in.
Okay, so the first of all, I want to tweak something we said about the FTC proposed rule. The proposed rule does not put a per se ban on these other clauses we're talking about: solicitation, liquidated damages, obligation to repay training and stuff like that. What it says is, though, that if those become overly broad, that they function as a de facto non-compete, then the FTC is going to come after those. So David, you might be back in business. You'll just be litigating those.
I was overstating. I know I'll be fine.
But you know what I'm saying? If you ban those, and then someone says, well, okay, you know what? They come out with this broad confidentiality thing, then the FTC might say, you know, that's a de facto thing. So those would be subject to enforcement. Okay. The other thing I want to say, and kind of piggyback on what David said, and this would be something you could all approach ISMS with. There are a lot of state laws out there, over like 26, that have different solutions that would apply to physicians. Okay. There are 11 statutes that apply specifically to physicians. And so, like, when you talk about these various locations where you practice, Connecticut defines primary place where the physician practices, and it's like it's going to be very state-based, right? But 5 miles from where that is, right? And if the employer terminates without cause, it doesn't apply. So and like in Colorado, says you can have a non-compete in there if you want to, but if you're taking care of people with cystic fibrosis and specific defined diseases, you can't stop them from seeing you. Okay. So, and there's other laws out there that'll say, like I think in Nevada, and then I'll be done here. It says, you cannot stop what is it? You can't stop the physician from practicing medicine. You can say they won't compete against you in that particular service you were providing for the employer, right? And maybe that's especially that maybe the physician is board certified in, but you can't prohibit the doc if he or she wants to practice medicine some other specialty during the time period. Or some other statutes say, look, the most you're going to be able to enforce is a year. A lot of states have that too. So what I'm saying is, regardless of what the FTC does, there are a lot of models out there that have worked out compromises that someone can look into that can really can put some significant restrictions on the use of the non-competes. And there are plenty of models out there, and plenty that apply to physicians and healthcare generally. And states, a lot of these are recent, and there's a lot of activity in the states now. So I have that information if y'all are interested in that as well.
I'm interested in a lot of that, Wes, and I'll make my plug for the Advocacy Resource Center at the AMA, because they always provide state medical societies with incredible background on many, many issues and what other states are doing, and it's very, very helpful.
Yeah, and we've got a big template, like 62 pages, that just discusses, compares and contrasts all these statutes. So I think I've given that to David. You can get it from him.
I think things I want to say about this.
I think Florida, if you're like the only one who does a specialty in a county, they can't touch you. There's something like that.
Yeah. Then states have that. Even the ones that aren't directed specifically to physicians, the non-compete has to apply to the service that you were providing to your previous employer.
And maybe that's a piece we haven't talked about. That is the crux of these enforcements. If somebody goes to enforce, they're going to need to prove that the agreement was done right. So you sign an agreement after you're hired, a month after you're hired, invalid, unless they pay you. You sign an agreement that didn't give you 14 days to review it before you signed it, and advice to go to an attorney before you sign it, invalid. there are all kinds of nuance to the protectable interest and the extent to which geographically they can enforce. So the things we were talking about earlier, where there's like a national agreement, these sound to me like anecdotes. I would be shocked if you found that there is an Illinois court that has enforced a person moving to this state from out of the state of Illinois and had their old employer in another state enforce a non-compete in the medical context. It just would not happen.
So, but this goes back to one of the questions we have from one of my clones. I'm sorry, whoever that is a good question. I guess sort of when will we know how this turns out? Which is another way of saying, when will we know we can start? Really, again, I just want to be transparent as I've been here all along. I'm a huge proponent of getting rid of non-competes. If you look at the FTC, what they wrote, and they had a few examples about physicians, but they had many other examples that non-competes actually raise the wages of those physicians or those people in the non-competes. They increase availability and competition and services to that community. It is a profound benefit to the public good. And that non-competes inhibit competition, restrain trade. And by the way, David, David Becker, I'm sort of shocked you haven't said this about what lawyers do about non-competes. David, you want to?
Oh, that was your favorite. I apologize.
How ethical
we
compared to physicians.
We as a profession have determined that it is not something that you guys all have a right to have the counsel of your choosing. And as a result, I can't be subject to a non-compete. So, and I believe it's also case law in the state of Illinois as well.
So this might get some people a little bit upset, physicians upset this, but I guess what you're saying is, David, is you're just a little bit more ethical than a lot of physicians who support non-competes. Is that what you're saying?
No, I'm saying I have a different body of ethics. You guys have an ethical rule that suggests that they should be reasonable.
Okay, so let me I want to make sure, because I'm going to quote you. I'm going to steal that line from you, David, from that lawyers are slightly more ethical than doctors, but I'm just paraphrasing.
I didn't say that. You said
I know, but I'm paraphrasing. I'm going to do that. But so what I'd like to do is just the question is, when will we know how this turns out? And will this? So there's a friend of mine, Kevin, who's with a large single specialty group. I don't know if he's on. I can't see the names of the people on. But he told me he thought this will never, they're lawyers, and he is part of a large multi-state group of physicians. But Kevin said, our lawyers tell us this will never pass. This won't affect them at all. Then I talked to Wes and said, private equity are the most vulnerable to this. So I just want to ask all the three of you, what are the chances? First of all, what's the time frame? I have a three-part question. What's the time frame we'll know how this turns out? What do you think is going to turn out? And how can people on this phone call who are passionate about this, how can we get involved to affect this outcome to the ways we think best, whether you're pro non-compete or anti non-compete? I'll talk, Wes, I'll start with you and then we'll just go around the corner.
All right. Well, okay. So, this is all speculation, right? Let me say, I wouldn't be surprised if, obviously going to depend on what's finalized, but I wouldn't be surprised that, we would have some kind of rule. Maybe it applies to physicians, maybe it doesn't. Maybe it's a cutoff at a certain income. That might be another thing. Maybe they come out with something that just applies to high-paid executives, something like that, right? Okay. I would expect that once it's finalized, you might have someone challenge it, maybe in a conservative state, in a favorable forum, and try to convince a judge to enjoin the rule. And then on various grounds, the FTC doesn't have authority to do this. This is really kind of something of this scope and something of this new, particularly since similar legislation has not been enacted by Congress. There'd be questions about like if the FTC is authorized to do this and so forth. And it would go up to various appeals. And so, we would have to probably wait until that process is done. Might go up to the Supreme Court. Who knows what the courts would do with it. So I think that's what we would expect. How long that would take? It would take a while, I would think. So this is probably kind of a longer term issue than just simply, the FTC will receive comments and, by March 20th or 60 days after that, and then it'll be like a done deal. I think it's going to be subject to significant challenge by the U.S. Chamber of Commerce. There'll be a lot of issue between the for-profit and the nonprofit hospitals. So that'll be a lot of what's going on, which will add some time to it, I would suspect.
Just for the record, just to correct, I want David to talk about this, but I don't know if you can define banning non-competes as a liberal or conservative point, because I think
well,
I
don't want to step on you, but I'm not going to use big L or big C. I'm going to tell you, based on the conservative majority in the Supreme Court, highly unlikely this gets fully enacted and enforced.
Really?
The Supreme Court has been ratcheting down the ability of any agency to do anything without a matching act of Congress. So this is all, I think, interesting conversation. The rule may get enacted next couple of months, who knows? But unless Congress does something, my take, nothing happens. And it does go to the Supreme Court, and they use it as an opportunity to say that agencies can't do anything. So if you want this to work, I'm going to give you a quirky little recommendation. Vote Democrat.
Really?
Yep. Listening to Wes's sort of speculative roadmap, I would say 3 to 5 years minimum. Because it will be challenged left, right, and center. I'm really curious to find out if the Illinois Hospital Association has even talked about this in public, if they're going to have any forums amongst their hospitals. I haven't heard anything from them, but I am curious to see if they have any reaction whatsoever to this, or if they're just going to stay out of it, including the American Hospital Association. I assume they're going to stay out of it because they've got a mix of members who are nonprofit and profit. And I don't know. We'll see.
David, was a really interesting point. There was a coalition of 100 organizations, they include the U.S. Chamber and the American Hospital Association, that have petitioned for an extension of 60 more days to comment on that rule. But I would imagine they would have some conflicts there among their members. You're right, between the for-profits and nonprofits. Yeah. And so, anyway.
So the interesting part, counter to what David says, everything I've seen, I've read, this promotes more competition. It promotes better care. It promotes better outcomes. It'd be pro-patient. And then the whole thing about doctors being heroes during this COVID crisis, it would be the biggest support for them I can imagine. And it's
if you really want that to happen, call your local state representative and ask them to work on adding something relating to doctors into the Illinois Act.
Yeah, that's great.
Because that is more likely to effectively accomplish what you're looking to see happen than the FTC.
So what's interesting, just to let you know, and this goes back to how important it is for physicians to be involved with organized medicine. So David Porter, and I've known David for decades. I asked Dave, because Dave is my mentor in trying to figure out how to do things. He's helped me my passion about hepatitis C, but I So David is going to help me. And by the way, David is a brilliant administrator. He's neutral on this. I don't want to get him fired about doing this, but
Thank you.
I'm hoping that we can find a way to get Illinois State Medical Society to support banning restricted cover and non-competes in the state of Illinois. And as I said, the non-competes have changed so profoundly in healthcare that this is not a big C, little c, big C, little, I mean, it's not a Democrat. It is an issue that you are harming the public good by restricting physicians and healthcare providers from providing the best care they can and the best environment they can. Right now, without mentioning any specific private equity or hospital chain, but when hospitals hold the ability to block physicians from doing what's in their best interest, they're not only hurting that physician, they're hurting what's best for the patients they serve and the community they serve, because they're making that physician less productive, less happy, and often they leave the community. So I am such a passionate advocate about this. So the only thing I will say, and I just see Larry K, Dr. K come up on my screen, I will say that not only am I working with the Illinois State Medical Society, there are people in my professional specialty society that work towards this, that the more people we get, the physicians speak out and say, this is not in the best interest of physicians. This is in the best interest of our patients. And that's why I hope this changes. And that's why I hope, and there are some people on this call, I know Larry is one of them, and I want Larry to speak in a second if he can. But there are people on this call that are national thought leaders within their specialty organization that mentor young physicians, that mentor our future leaders in medicine, the people that are going to be replacing us in 10, 20 years. We should do everything we can to make sure they have the best and greatest career they can possibly have. So that's my little thing. So I see that handsome gray-bearded man in the corner. Larry, do you want to say anything?
You just said just a couple words. I think couple of really important statements tonight. First one was, the patient is the one we should be thinking about. What's in the best interest of the patient? And the second thing is that this is probably not going anywhere for a very long time. But, we all have interests one way or another investing in companies from Silicon Valley. Not too many non-competes in Silicon Valley. Not too many non-competes in Israel. And if you really want to seed intelligence all over the place and make things better, non-competes are a real problem for that. But we need to make our focus on the patient, and I would hope the AMA, Wes, has that focus, because it should be what's best for the patient.
But all, and Larry, that's so true. So ultimately, this is what's best for the patient. This is what, keep your doctor, have your doctor find the best job.
I agree.
Don't inhibit them from doing what's best for themselves and their patients. And our national organizations, including the Illinois State Medical Society, thank you, David. And boy, David, I guess I'll be buzzing your ear about our CMS meetings coming up in the coming months. But bringing it back to the AMA, because you know what, things have changed so profoundly since the AMA and Illinois State Medical Society. We are being employed by people who have never, ever taken care of a patient, who's never seen a patient die, who's never been with a patient and brought them back to life, who has never done the things that we've done on the front lines. And physicians, whenever you do what's best for physicians, it usually is best for the patient. Whenever you do things that are best for venture capital, it's usually best for venture capital, and other people suffer. I should have said that. Maybe I went too far, but I think when you do what's best for the patient and the physician, they go together much more aligned than any of these other aspects. So it drives me crazy, but I hate what Larry says is going to take time, and Wes said that, and David said that. But you know what? Most of us on this call, we sort of are smart enough. We've gotten out of the non-competes, but many of us were in non-competes at one time, and we have people we care about that are behind us. We want to do what's best for the people who follow us. We want to do make them have the best career so they have the best way of taking care of patients. Have them have non-competes. Have them have the freedom to do what's best for patients. That's just my, okay, I'm getting off my soapbox. I'm seeing David Porter saying, okay, you've done enough talking, but are there any other comments anyone else makes?
No, David Becker needs to go home.
You know, I didn't want you guys to have to listen to my barking dog.
Okay. Thank you.
Dr. Yap, thank you for organizing this. This is interesting.
I really appreciate this. And by the way, I'm going to go one more last plug. The AMA, the Illinois State Medical Society, and the DuPage County Medical Society organizations that really are fighting for doctors and patients. So please, if you want to get involved, I hope you think about joining and helping us do what we're doing. And David Becker, you are clearly a resource that many on this call and beyond this call should know. We would love to.
I'm going to put in the chat. If you ever, anybody wants to get me, I'm putting in the chat my email address.
And David Becker, we'll make sure you have on the DuPage County Medical website, we'll have your contact information. There it is. Great. Thank you, David. And we'll also have, I think Kate and Kirk, our brilliant administrators at DuPage County Medical Society, will have this on our website, which is DuPage DCMS doc. There you go. That's a plug right there. I like it. So thank you, Kate. But dcmsdoc.org. Please tag on. We can help you not only join the DuPage County Medical Society, we can also help you with Illinois State Medical Society and also help you with the AMA. And we'd love to have all of you involved. So, and this conversation will be on our website. The brilliance of Kate's IT magic will make it on our website. And we really look forward to working with all of you and fight the fight for physicians. All right, I'll end it there. If there's any questions, thank you everyone very much. I look forward to working with many of you in the near future.